Then 545 minutes. There is no automatic or self-executing consequence to crossing the time limit. It simply triggers judicial scrutiny. A timeline set by this court does not mean that the governor is mechanically bound to act within 1, 2, or 3 months in all cases. Rather, it means beyond the prescribed period. If an objection is raised, the governor or the executive as whole must satisfy the court that the delay was justified and free from abuse. Quite frankly, Maharaj, this is not relevant because that's not my argument. This is what the Tamil Nadu judgment says. Now, Maharaj, kindly see para 46. That's very important, Maharaj. The timelines prescribed by this honorable court are also based on the following. Maharaj, Tamil Nadu provided some timelines, but based on what? Office Memorandum of the Ministry of Home Affairs, Government of India, dated February 4, 2016, issued to all ministries and departments of the government, acknowledging the undue delay in clearing reserved bills despite an earlier guideline of 22nd September 92. The memorandum thus admits that decisions on reserved bills must be taken expeditiously. That's the memorandum on which was Tamil Nadu relied. Well, that's the constitutional purpose. Sarkaria Commission, Punchi Commission, both recommended timelines. I'm not on timelines at all, Malas. My argument is different. You give them timelines, they breach the timelines, you destroy the constitutional working of the Constitution. Then, Malas, judicial review. You want me to read it? Not necessarily. I've already made the argument. Yes, yes. Then you come to
131.
No, kindly come to para 52, Maharaj. Para 52. Because my learned friend talked about justiciability. He said, it is not justiciable. It's not question of judicial review doesn't arise. Well, let's kindly see para 52. An absence of judicial review may be presumed in areas such as fundamental duties under Part 4A of the Constitution and broad economic policy. These are rules of evidence. You don't have the facts. Further, matters relating to relationships of confidence, which are protected by the concept of privileged communications, are not matters for judicial review. This is based on the principle that the rule of evidence does not allow them to be matters for judicial determination, because you just don't have the facts. Similarly, acts of the executive in which law and order is required to be maintained in respect of in situ situations are again not matters for judicial review. 371A, 371H. This is reflected in the discretionary actions of the governor under 371A, which are pure executive actions and cannot be regulated through judicial determination. However, the principle does not apply to specified constitutional obligations of either the executive or the legislature. Well, there's another argument was made, see, you have timelines. Wherever the Constitution wants timelines to be provided, they are provided, but all of them are legislative. There will be a 5-year term of the Assembly. There's a 5-year term of Parliament. That's the bedrock of democracy, timeline of legislation. Elections will be held in such and such time, within 6 months of the Assembly being dissolved. This is not in the functioning of the executive. If there exists a provision, the contours of which are clearly established, within which the executive or the legislature is to function, and which impacts Part 3 of the Constitution, or is reflected in constitutional provisions delineating the powers and responsibilities of the constitutional authorities, then such action is subject to judicial review and is justiciable. Article 200 is one such provision. It is not a provision that requires the governor to be satisfied, as in the case of 356. Therefore, the question of justiciability does not even arise. Thus, Article 200 is within the powers of the court's judicial review. Then, Maharaj, judicial review is invited the moment he kindly comes straight away to 59 now. Oh, sorry, what? 59, yes. Now, my lords, 59 is Rameshwar Prasad, right? This is page 908. Malas, if I may, Malas, just read 361 with you again, Malas, your lordship permits me. Just so that we clarify the contours of 361.
Yes, sir.
The president or the governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of powers and duties of his office, or for any act done or purporting to be done in the exercise and performance of those powers and duties, provided that the conduct of the president may be brought under review by any court, tribunal, or body appointed or designated by either House of Parliament for the investigation of a charge under 61, provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceeding against the government of India or the government of a state. Just pause here. If you allow the governor the personal power to take a decision, neither the government of India nor the government of the state is involved. How will 361 apply when it's the decision of the governor that I will not give you assent, or that I'm keeping the bill pending? Government of India can't defend him. Government of a state is at odds with him. How will a writ petition lie? You can't interpret 361 in this fashion. If you give that power to the governor, if you give that power, my argument is that you should not do so. But if you do give that power, then he's answerable. Then 361 will not stand in the way. You can't have it both ways. You take recourse to 361 saying he's not answerable, and you give him the power under 200, and you say government can't, governor will not file an affidavit, and court can't issue a process, then you're making the Constitution unworkable. Because that's the only act in which he is not accountable. There is no act in the Constitution which makes the executive not accountable to the court. But this is a provision where you will give that. You can't have an absence of accountability as a constitutional provision. Therefore, mother, that's why I've been saying time and again, the governor has no such power. This situation should not arise, should not be allowed to arise, is not constitutionally permissible. He has to give assent. The president has to give assent. And litigation will take its course, whether it is repugnant, not repugnant, whether it violated a constitutional right of citizens, did not violate, whether whether the legislature had the capacity to enact the law. These are situations that would arise in the course of litigation, and you will decide. But he has no power not to assent. Only question your lordships have to do, if despite that he does, then what's the remedy? That's the only area where you have to create an architecture for a remedy. Either deemed assent or some other. Just wanted to flag that issue for your lordship's consideration. Then, Malads, Well, it's really, Rameshwar doesn't answer that question. I'm just, well, since your lordship said, doesn't answer that question. Because again, well, the problem that with us lawyers is the following, well, and I must concede that we are guilty of that. We take out a sentence from one judgment and we say that it's the exposition of the law, realizing that every judgment is contextual, arises from the facts of the case, has no bearing on another issue, where the facts are not before you. And there are very famous words. It's not part, but we've handed over a hard copy. Just have a look at that since I just finished this aspect. This is an Oriental Insurance Company versus Rajkumari. Para 11. Just give the judgment, please. I'm sorry, Malat, but we'll put it in the...
यार चाचू आ गए हैं टैक्स फाइलिंग में हेल्प करने।
तू खुद फाइल क्यों नहीं करता? क्लियर टैक्स पर यहाँ पैन और ब्रोकर्स लिंक करते ही तुम्हारा कैपिटल गेन्स, एफएनओ, क्रिप्टो सारे इनकम अपने आप कैलकुलेट हो जाएंगे।
अब नेक्स्ट इसका प्रॉफिट उसका लॉस सब एडजस्ट हो जाएगा।
बस करना है नेक्स्ट।
अब आया पूरा टैक्स समरी, बेस्ट रेजीम, आईटीआर फॉर्म्स सब रेडी ताकि तुम्हें मिले मैक्सिमम रिफंड
एंड फाइल। मैक्सिमम रिफंड, 100% एक्यूरेसी, क्लियर टैक्स, इधर नहीं तो किधर।
At the bottom, if I may read, reliance on the decision without looking into the factual background of the case before it is clearly impermissible. A decision is a precedent on its own facts. Each case represents its own features. It is not everything said by a judge while giving a judgment that constitutes a precedent. The only thing in a judge's decision binding a party is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate it from the ratio descendi. According to well-settled theory of...
Said in Dhanvantari Devi.
Yes, exactly. That's why, Malaj, in the 2G case, when auction was prescribed for telecom, in the telecom sector for spectrum, the question arose, does it apply in every other case? And your lordship said, well, as far as spectrum is concerned, it's fine, but it can't apply to other cases because the fact situation is different. So, Malaj, how can a principle of law, say in Nambudiri, for example, it was said that the House stood dissolved, the Assembly stood dissolved, and the matter was pending before the President. And since there was no timeline, even if the Assembly is dissolved, the bill can be passed. Right, Manas? That's what Nambudiri says. The argument is the court has said no timelines. Therefore, no timelines in 200. What's the relevance of that to what we're discussing today? So you can't take a judgment like that and set up a constitutional principle that no timelines will apply in 200, when that was not the issue before the court. The question is whether the bill survives or not, because it's awaiting the consent of the President, and the court said it survives. That's the mistake we commit. So it says, findings of material facts direct an inferential finding of facts is the inference which the judge draws from the direct or perceptible facts, statements of principles of law applicable to legal problems disclosed by the facts, judgment based on combined effect of the above. A decision is an authority for what it actually decides. What is of essence is that in a decision is its ratio, and not every observation found therein, nor would logically flow from the various observations made in the judgment. The enunciation of the reason or principle on which a question before a court has been decided is alone a binding precedent. Case is a precedent and binding for what it explicitly decides and no more. And this goes onwards. Courts should not place reliance on decisions without discussing as to how the factual situation fits in, that's para 12, with the fact situation of the decision on which reliance is placed. Observations of courts are neither to be read as Euclid.
That's what Dhanvantari Devi says.
That's right.
Slight distinction in fact,
That's right. So well, let's not,
with application of the same law,
yes,
will lead to divergent results.
correct. So you can't apply 356 to 200. You can't apply Nambudiri to this. You can't apply Veluri to this. Then, this is at 909, para 60. I've done my argument on 361 already, so I will not read it, It only talks of 361. Then comes, the 131 and 132. Now, before that, kindly come to an issue that I wish to raise, not on maintainability, but kindly have a look at, where's that table? No, the table where, previous table. Yes. In Annexure A, page 911, Now, I have set out here all references made in the past, all references. And no reference in the past is similar to this one, because in each reference, there is a specific question asked. In each reference. I'm not on maintainability. But I would request your lordships to be careful when deciding a matter of this nature, dealing with a hypothetical situation in the absence of facts. What has been directly argued is that the governor has immunity, that he can withhold assent, that your lordships must answer. But there are several peripheral.
मेरी गाड़ी ठोकेगा?
पर गलती तो आपकी है।
मेरी गलती? तू जानता है मेरा बाप कौन है?
ये देखो, पापा और गलती दोनों याद आ जाएंगे। अब देखा किसने सिग्नल तोड़ा?
Cubo dash cams. Think safety, think Cubo.
Delhi Laws Act 1912, in re 1951, SCC 568. What is the question? Was Section 7 of the Delhi Laws Act or any of the provisions thereof, and in what particular or particulars or the extent ultra vires the legislation? Would direct question, Mother, that your lordships had to answer on the light of the law that was operative. Then Kerala Education Bill, 1958 reference, does subclause 5 of 3 of Kerala Education Bill read with clause 36 violates, offends Article 14? Direct question. Come to Berubari Union, famous case, direct question. Kindly come to Sea Customs Act, 1963 Supreme Court. Direct, do the provisions of 289 of the Constitution preclude the Union? Direct question. Privilege immunities of state legislatures? Direct question. Presidential reference, 1974, direct questions. Special bill, special courts bill, direct question, whether the bill or provisions thereof, if enacted, would be constitutionally valid. In fact, Justice Chandrachud in this judgment, Senior Chandrachud said, that look, even this is very vague. You should have told us which are the provisions that should be held to be invalid. The court is not here to tell you whether the court is not performing that exercise. You want to ask me a question, you ask me a question. I'll cite that just now. Kaveri water dispute, direct question. Ismail Faruqi, direct question. Special reference, 1998, direct question. Jammu Kashmir grant of permit of resettlement, direct question. Special reference 201, direct questions. Special reference 202, direct questions. Natural resources allocation, direct question. Tell me which reference has ever been made like this? You're asked to answer on all kinds of assumptions. All kinds of scenarios are put before you. Is that the duty of the court? To not conjure up scenarios and then answer a question? What will happen in 131? What will happen in 32? When it happens, then you'll answer that. You'll answer that through your judicial process. Well, you're not going to take examples like that and answer questions. It's the job of the government or the president in the reference to tell you, this is what we are troubled by. Does arise or likely to arise? How does Maharaj 131 likely to arise? Or 32, whether it lies or not likely to arise? How is it relevant? So, Maharaj, now let's look at that. First of all, Maharaj, what Justice Chandrachud said in Rebel. That's which is that? Volume 9. Page 3685, PDF 184, para 30. This is where they said, you just tell us whether the bill is unconstitutional or not. What does Justice Chandrachud say?
Page number?
Page 3685, PDF 184, paragraph 30, volume 9. You'll just have it, Maharaj? My Lord Chancellor. Has it? May I read it, Maharaj? May I read it, Maharaj? We hope that in future, whenever a reference is made to this court under 143 of the Constitution, care will be taken to frame specific questions for the opinion of the court. Fortunately, it has been possible in the instant reference to consider specific questions as being comprehended within the terms of the reference. But the risk that a vague and general reference may be returned unanswered is real and ought to engage the attention of those whose duty it is to frame the reference. Were the bill not as short as it is, it would have been very difficult. It would have been difficult to infuse into the reference the comprehension of the 2 points mentioned by us above and which we propose to decide. A long bill would have presented to us a rambling task in the absence of reference on specific points, rendering it impossible to formulate succinctly the nature of the constitutional challenge to the provisions of the bill. And somewhere else it is said that it can't be hypothetical. Yes, then Miller's para 26. This very important para 26 at page 3684. The second objection, this is an objection to maintainability. I'm not on maintainability, Miller. We're beyond that. The second objection to maintainability of the reference is that it is vague, general, and of an omnibus nature. The question referred to by the President in this court is the following: whether the bill or any of the provisions thereof, as if enacted, would be constitutionally valid. It is true that the reference does not specify with particularity the ground or grounds on which the bill or any provisions may be open to attack under the Constitution. It does not mention whether any doubt is entertained regarding the legislative competence of the Parliament to enact the bill, or whether it is apprehended that the bill, if enacted, would violate any of the fundamental rights, and if so, which particular fundamental right or rights. A reference in such broad and general terms is difficult to answer because it gives no indication of the specific point or points on which the opinion of the court is sought. It is not proper or desirable that this court should be called upon to embark upon a roving inquiry into the constitutionality of a bill or an act. Such a course virtually necessitates the adoption of a process of elimination with regard to all reasonably conceivable challenges under the Constitution. It is not expected of us, while answering a reference under 143, to sit up and discover, article by article, which provision of the Constitution is most likely to be invoked for assailing the validity of the bill if it becomes law. The court should not be driven to imagine a challenge and save it or slay it on hypothetical considerations. Save it or slay it on hypothetical considerations. As observed in Hamilton, speculative opinions on hypothetical questions are worthless, and it is contrary to principle, inconvenient, and inexpedient that opinion should be given upon all such questions at all. It applies directly to this case.
Read 27.
We are at one stage of the arguments so much exercised over the undefined breadth of the reference that we were considering seriously whether the circumstances it was not advisable to return the reference unanswered. But the written briefs filed by the parties and the oral arguments advanced before us have, by their fullness and ability, helped to narrow down the legal controversies surrounding the bill and to crystallize the issues which arise for our consideration.
In
We
2G,
close to limit.
in 2G, DK Jain explains
Yes.
what is to be done by a reference court
Yeah.
when there is uncertainty about the
Yes.
claim.
Now, if you look at the questions here, you are conjuring up issues, Manoj, which may never arise. Now, just look at the questions, Manoj. Yeah, right, yes. I'm not going to delve much on it, Manoj, just so that you have to, in ultimately deciding this matter, have to be careful where you want to give an opinion and where you don't want to give an opinion. Volume 3, Manoj. Page 7.
Volume 3, page.
Manoj. Page 7, Manoj.
PDF page 7?
Volume 3, page 7, Manoj. Index and documents, volume 3, Manoj. It's part of the
You come to volume 3.
volume 3, Manoj. Index and documents, volume 3, Manoj, page 7. It's now, as far as 1, 2, and 3 are concerned, they arise. Only they are specific.
Yes.
I have no problems with that. 1, 2, and 3. Though constitutionally, 1, 2, and 3, Manoj, whether constitutional options before a governor when bill is presented to him under 200. I mean, it's not in the context of any facts, Manoj, but let's assume, Manoj, that your lordships can consider reading 200 and answer that. Then is the governor bound by the aid and advice standard? Let's assume that. Is the exercise of constitutional discretion under 200 justiciable? Then Article 361 is an absolute bar. Manoj. How does that arise? What's the relevance of that here? No such thing has happened. Why should you answer it? The absence of constitutionally prescribed time limit. Why do you assume that? You're going to interpret 200, interpret 200. You can't assume that there is no prescribed time limit. How do you assume that question? Assume that it requires to be decided. You interpret 200 in the matter that constitutionally, and then that will be the end of the matter. Why do you assume that there are no constitutionally prescribed limits? It's an assumption made, Manoj. Can't be a question on an assumption in constitutional law. Is the exercise of constitutional discretion of the president, it's all part of 200. And that's not arisen in any situation, my lords. Kindly see. This question of 201 has not arisen in any situation. You're asked to answer the question. In a fact situation, if it arises, you will answer it. At the moment, it is obvious, my lords, and I can say it up front. It's obvious there's a judgment of this court and somebody wants to say that, no, that's not good. In the light of constitutional scheme governing the powers of the president, is the president required to seek advice of the Supreme Court by way of a reference? You're directly dealing with the judgment. If that arises, you decide it. But you're directly dealing with the judgment, which is prohibited, as you know. It will be challenged, Mullahs. I'm sure it will be challenged. You may set it aside. No problem. But this is no way, Mullahs, to get an answer. Are the decisions of the governor and the president at 201, 200, 201 justiciable at a stage anterior to the law? How is that? Is that arisen anywhere, Mullahs? Anterior to the law? Has it been said by any judge, Mullahs? Can the exercise of constitutional power and the orders by president be substituted in any manner under 142? It's not arisen. It has arisen in a particular context and the particular facts of a case which was rendered, on which a judgment has been rendered. You can't tangentially, Mullahs, attack the judgment in this manner. Yes, you can say that judgment is wrong and it will happen. It will happen one of these days in some other case. You go for review, you go for curative, or you in another case, attack it. And many a time your lordships have changed your mind. There's nothing wrong with that. Is the law by the state legislature a law enforced without the assent of the governor? How is that arisen? Then 145.3, then 142, then 131. All these questions, Mullahs, with the greatest respect, should not be answered. The only parameter that needs your lordship's careful consideration is Article 200 of the Constitution in the context of the power of the governor. Nothing else has arisen. So it's not about maintainability. It's your lordship's discretion in the exercise of your constitutional duty through a reference that is asked for to answer questions that your lord might wish to answer, might not wish to answer. Now, as I go back to my submissions, 2.5. Now, what is left? Well, I'm not going to argue 132 because I think it shouldn't be answered, Mullahs. I've done, Mullahs. I'm deeply, deeply obliged. I have, Mullahs, not repeated a single argument, and I have tried to save time so that my colleagues can argue.
But before my learned friend starts, on the lighter side, while arguing on the maintainability on the first day, since Dr. Singhvi led the arguments, but my learned friend my lord did not, but virtually he did that at the end in a different form, that it should not be answered because it is not made.
Some may be answered, some may not be answered.
No.
He is supported by judgment of the Supreme Court on that.
Yes.
He first referred to the judgment, Justice Chandrachud's.
I will deal with that, my lord.
You may
If you would have argued that at the outset, I would have dealt with that.
I never,
then.
in fact,
Now I will argue. We will, my lord, deal with those judges.
I never wish to argue maintainability because I don't believe that it is not maintainable. But I do wish to argue that many of these questions should not be answered.
Yes, my lord.
And I'm entitled to argue that.
How,
That you may do it in the rejoinder.
in my rejoinder, my lord, without the flavor of my learned friend, I'll argue, my lord, straight
He
answering.
has his own peculiar favor in every case,
Yes.
which we appreciate.
Yes,
Deeply obliged.
obliged.
What has been decided by your side with regard to request of Mr.
இந்த ரீல நீ பாத்தியா? இதான் இப்போ ட்ரெண்டிங். இந்த வீடியோ இது வைரல் ஆகுது. இது பார்த்தேன்.
ரெண்டு சக்கர சவாரி பெருமையோட பாயுதே ஹீரோயிசம் வீடு இங்க கொஞ்சம் கவனம் கூடு ஐஸ் மாதிரி கூல் ஆனா ஃபுல்லா ஃபயர் தான் துணிச்சலின் சத்தத்தை கேளு
Tough, I'm feeling unforgiving. Fall out like I live the place, the skin on you is spinning. Craving the adrenaline, walk like my dog, you're never ready.
துணிச்சலின் சத்தத்தை கேளு உலகம் விரும்பி பார்க்கும் நீ செஞ்சு காமி
No, that is an issue to be decided amongst yourselves. So, yes,
You take an hour, then he has enough time.
we'll be finishing within an hour.
An hour, maybe an hour and 15 minutes.
Then it will be done.
My Lord, I want to place the matter on behalf of the state of Karnataka on principles of constitutional interpretation. And I think, my Lord, the reference seriously entrenches upon one of the most acknowledged, consistent, and coherent principles of the Constitution, which is, my Lord, the democratic organ which enjoys executive power is the cabinet form of government. And this, my Lord, is central to the issue. Because if the cabinet form of government is the quintessence of a parliamentary democracy, which your lordships have upheld, reinstated, reiterated, right from, my Lord, 1954. And if that is so, then, my Lord, one has to discover what is the role of the president and the governor. Unless, my Lord, we have this picture clear, we will not be able to answer the question with reference to Article 200. My Lord, the law has taken a consistent position right from 1954 that both the president and the governor are titular heads. And the true executive power resides in the cabinet, the ultimate cabinet, whether it is the union cabinet or whether it is, my Lord, the state legislature. In fact, my Lord, Dr. Ambedkar, very far-sightedly, in a speech of 26th of November 1949, amply clarified that both the central government and the state government, both the central legislature and the state legislature have independence and are meant to be treated equally. I will not place that except from the speech. But, my Lord, there is a second principle on which your lordships will have to entertain this reference, which is the theory of collective responsibility to the House. Well, there are two principles. One is the cabinet form of government. The second is that cabinet form of government is collectively responsible to a legislature. Well, both these principles will be violated if either the governor or the president, my Lord, is given or is endowed with any form of discretion. If anything is to be indicated, my Lord, it has to be found in the text of the Constitution. For instance, my Lord, the president, after the 44th Amendment, by virtue of the first proviso under Article 74(1), can remit a matter to the cabinet for reconsideration. But after it is reconsidered, the advice is binding on the president. Under Article 103, my Lord, in respect of a disqualification, he is bound by the advice of the Election Commission. in order to discharge a judicial function about the age of a judge of the High Court, under Article 217(3), he consults only the Chief Justice and acts independent of the aid and advice of the Council of Ministers. These are the only two exceptions, my lord, for the president. As far as the governor is concerned, my lord, there are three sets of functions. The first is executive power, which is vested completely in the governor. The second is, my lord, he enjoys no legislative power. My lord, please take it from me, he enjoys no legislative power. The third is, my lord, functions for discretion are specifically nominated in the Constitution. And functions for reservation for consideration of the president are also identifiable in the Constitution. So, my lord, the question of high constitutional functionary enjoying plenitude of discretion, my lord, is completely anathema to the Constitution. And more than anything else, my lord, Keshavananda Bharati was resting on the pillars of the parliamentary form of government where the cabinet exercises the real power. In Keshavananda Bharati, your lordships equated the governor and the president in the constitutional sense in totally equal terms. So, my lord, I would submit with great respect that the first question for consideration is, what is the true relationship of the president and the governor to the cabinet government? This is the first question. And it is only then, my lord, we can come to the second one relating to Article 200.
Should we start at 2 o'clock?
Very well.